The Supreme Court is now in session. The Honorable F. Philip Carbolito, Chief Justice presiding.
Good morning, counsels. Will the clerk please call the case?
This is Supreme Court case number CVA20-020, Vivian Ujoa McCurdy, Plaintiff Appellee versus Chamorro Equities, Inc., Defendant Appellant. Appearing for the Defendant Appellant is Attorney Daniel J. Berman. Appearing for the Plaintiff Appellee is Attorney Jacqueline Taitano-Terlahi. The panel consists of Chief Justice F. Philip Carbolito, Justice Pro Tem John A. Manglotya, and Justice Pro Tem Joseph N. Camacho. Attorney Berman reserves 5 minutes.
Thank you, Madam Clerk. And for the record, I again would like to thank Justice John Manglotya and the Honorable Judge Joseph Camacho for agreeing to sit in as pro tem justices in this case. And Mr. Berman, you may proceed.
Thank you, Your Honors. May it please the court. My name is Daniel Berman, and I represent Chamorro Equities, Inc., or CEI. CEI is a closely held family corporation founded by 7 Ujoa siblings in 1987. We are before the court on appeal from a final judgment ordering CEI to transfer title to its house and land in Agana to the estate of the deceased Lucy P. Ujoa. We'll call her Lucy in this argument. And the property we call AHR, or Agana Heights residence, where Lucy lived her adult life between 1990 to 2014. The complaint was not filed by Lucy Ujoa. In fact, the complaint was not filed by the estate of Lucy Ujoa, which is represented by the appointed administrator, Office of Public Guardian, Attorney Ms. Marceline Santos. Ms. Santos testified that she did not support this action complaint by Vivian McCurdy. Instead, this plaintiff is Vivian Ujoa McCurdy, one sibling out of 7 of the Ujoa family. We argue that Vivian filed this complaint only in retaliation for being evicted from the AHR while she held over an adverse possession after Lucy's passing in 2014, and only after her stock of 1/7 interest in CEI was involuntarily taken as security in 2016 for a $500,000 secured loan that she could not pay at that time, and only after Vivian was removed as executor of the estate of Lucy, quote, for want of integrity in 2016. Let's talk about the facts and background. The first plan of CEI in the early days, back in late 1980s, early 1990s, was that the 7 siblings agreed that each sibling would receive a lot in Agana Heights, Guam. But the plan changed, and 3 of 7 siblings received cash of $375,000 for home purchases. Those are George, Esther, and Vivian. A second plan and actions became apparent. Priscilla.
Mr. Berman, I think we're familiar with the facts, and I'm intrigued by your argument in terms of the Land Registration Act. However, Attorney Terlahi argues in her brief that that CEI did not preserve this issue on appeal, and that it failed to raise this at the trial court level. And of course, I note your arguments in your brief, but maybe you can elaborate on that and to explain to us why this is not the case, and that why this matter is, this issue, this argument can be entertained on appeal.
Thank you, Your Honor, for the question. As you point out, our reply brief does address that particular argument. First, the evidence in the trial court was offered and admitted at ER 284, Exhibit D64. That's the evidence of the Superior Court petition for land registration and the Superior Court decree registering title. That's ER 278 D63. In the closing argument in the case below, we submitted as ASER 0607, the July 23, 2020 closing argument that I made, where it is my first argument, petition for land registration. The CEI proposed findings and conclusions of law were submitted. It made that our first conclusion of law. The trial court failed to address the defense for reasons we'll never understand. Motion for reconsideration is not a prerequisite to an appeal. No estoppel exists against CEI. Instead, any estoppel is only against Lucy, who had signed the petition for land registration in 1995 and 1997, and signed the corrected warranty deed in 1995, 1997. That matter was preserved below by offer to the trial court of evidence and arguments made below. Thank you.
So if the issue is raised at the trial level for the reasons you explained, and the matter is before us on appeal, you argue the effect of the decree of land registration should control the outcome of this case, and that title was established in CEI through the warranty deeds that were conveyed, and the decree of land registration, which you point out is was introduced as an exhibit and was presented to the trial court. So my question is, what is the time period for a party to challenge a decree of land registration? That didn't seem to be an issue at the trial level, but when can a party then challenge a decree of land registration to say that the decree or the deed doesn't really stand for what it represents and is subject to some type of cloud or some type of claim?
Thank you, Your Honor, for the question. The background facts as we know them is that, of course, Lucy signed the petition for land registration, and Lucy signed the corrected warranty deed back in the 1997. But in our statutes of limitation, there is, at the longest time duration, a catch-all statute of limitation that is no more than 4 years. There probably are other statutes of limitation that are shorter than 4 years, but no statute of limitation is longer than 4 years under the catch-all. And the catch-all.
Is there a statute of limitation specifically in the Land Registration Act in which any challenge to the initial registration must be made?
Your Honor, I apologize. I didn't see that issue in the appellate exchanges before today. I will assume.
There is a section, it's section 29146, 21 GCA 29146, that says any challenge to a decree of land registration has to be made within 1 year or be forever barred. And so if the shareholders agreement was made prior to the petition for land registration and decree for land registration, why would the estate not be barred from then challenging the decree if there was a 1 year statute of limitation?
Thank you, Your Honor. I would agree with the court's call of the question that they should be barred after 1 year. I was being just generous at 4 years under the catch-all, but I'm glad there's even a shorter statute of 1 year that should be applied.
Mr. Berman, what gave rise to the 1995 petition? Was there a probate of the Barron's estate? Because it seems like I know there was a 1987 transfer by the 7 siblings. So I guess what gave rise to that petition?
Thank you, Your Honor, for the question. To be candid, I'm a little uncertain of all the exhibits that went into the record below at this point, even though I was the trial attorney, because I recall that was not an issue below, as I think all counsel were familiar with that background. I don't want to speak of exhibits out of the record, but to my understanding, there was a probate, and the probate final decree was a distribution to the 7 siblings in equal shares.
I see. When was the decree issued?
I think shortly on or before 1987, before the warranty deed.
which decree are we speaking about, the probate or the land registration?
Justice Manglona is referring to events preceding the 1987 warranty deed. And as I understand it, that would have been the probate of the parents of the 7 siblings, Mr. and Mrs. Ujoa.
I see.
And the decree, I believe, to all siblings in equal shares of all of the property.
Council, can I switch gears slightly? In regards to the Chamorro Equities ledger into Lucy's house, was it specific to the house or was it specific to her? Meaning if she had moved to a different location, the payments of rentals and repairs and things of that nature, would it have followed her?
Thank you, Judge Camacho, for the question. I take your question to be aimed at the Exhibit 9 of plaintiff. That was the table of Ujoa sibling household benefits. And that table, of course, sourced from the plaintiff, I believe addressed each of the 7 shareholder siblings' receipt of distributions of house benefits. And because that period was 1987 to 2007, 20 years, that period actually would include those 3 years of 1987 to 1990 when the AHR, the Uganda Heights residence, was not yet complete with construction. The agreed date for complete construction was 1990. And in 1990, the agreed fact was that Lucy moved in, took possession, occupation of the 7-bedroom, 6-bath house. So before 1990, I don't think the table will tell us anything about Lucy's residence or what her housing benefits were. I take that table to be a statement of really 20 years of 1987 to 2007. And that small period of 3 years would be unknown what was happening vis-a-vis Lucy.
All right, so kind of the follow-up question to that is, were other siblings put on this ledger for the benefit of the whole family? Like, somebody else's taxes got paid or repairs, or was it just very specific to Lucy and or the Agana Heights residents?
Thank you, Judge Camacho, for the question. I believe no doubt exists that the table is not 7 siblings. The table covers all 7 shareholders who are 7 siblings. And there are 3, maybe 4 pages per sibling shareholder tracking not only housing distributions, but dividends or reimbursements or consultant fees. It's all identified on the table. Thank you. Returning to my arguments, if I may, Your Honors, we ordered our arguments in a priority of first land registration law that was based on the warranty deed, the Superior Court petition, the decree establishing title, and it followed up with the 1998 minutes of CEI that stated in 1998 that Part 4, Section 1, quote, Lucy's house, period. CEI owns the house, close quote. Lucy's present in that meeting and she signs the minutes. And for the 24 years between what was 1990 to 2014 death of Lucy, CEI itself, the company, paid all real property taxes. And it's agreed Lucy never paid any rent for use of the house that she resided in.
I have problems, even though Part 4 of that minutes says that it's, I guess it says that it's CEI's assets, but there are other minutes also that was pointed out by the trial court. And I see that there's mention to the December 1993 board minutes. It's pointed out in the briefs also that Lucy's home for the time being will be kept as CEI's assets. There were also minutes that say the 4 top lots will be, or the property will be partitioned into 4 lots, and then the remainder will go to CEI. So don't those minutes run counter to what CEI's position is now? I mean, even though there was a land registration in 1995. And in your brief, it was mentioned, page 5, and you did acknowledge that AHR was constructed by CEIs to be Lucy's house, and the lot would be later transferred. So I point these out because one of the factors of equitable estoppel is that there should be donors in that. I guess the donor here is CEI or the rest of the siblings. And that's clear in the record. So what is your take on that?
Thank you, Justice Mangland, for the question. The interpretation of the minutes that are sometimes in conflict or ambiguous are that wherever you find ambiguity or a striking contradiction, that's a trigger for statute of limitation to start running. Now you know, if you're Lucy, that you must take action. You're not getting what was promised. And that begins in 1990. The position of Vivian is that Lucy was promised and she should have obtained title in 1990. So what happens from 1990 to 2000, those 10 years? No doubt Lucy is lucid, competent, able, and working as a CEI board of director and shareholder, and she's signing all these minutes. She's president of these meetings. She, above all people, is most aware of what's going on in Chamorro Equities Inc., and she takes no action. And she took no action for, as we explained in our brief, for a very solid, substantial reason. She's receiving an equal or arguably a better performance by CEI for housing benefits. She is living in a 7-bedroom, 6-bath house that requires no rent payment, and she has her house taxes, real property taxes, paid by CEI. The repairs, the maintenance are paid by CEI.
Mr. Berman, but we know that property taxes, I was looking at the record that I guess it was ER 249 about the amounts of these taxes paid, and they're really not that significant. As you know, Guam's tax assessment or real property tax assessment rates are quite low. So over the 20-year period, it's probably less than what, $10,000 Lucy's share. And that brings me to the question: how much really did CEI spend for Lucy or Lucy's house during the 20-year period?
Thank you, Justice Mangland, for the question. Really 2 questions, if I could respond each one in turn. First, on the taxes. To clarify, whether the taxes are $100 a year or $1,000 a year, it's the meaning of taxes on 2 levels. If those taxes aren't paid, that house is levied and foreclosed for failure to pay taxes. So there's a burdensome requirement on the owner just to keep it out of levy and confiscation by the government, whether it's $100 or $1,000 a year. But the second part of the tax component is that, of course, it just relieves the taxpayer of that obligation. And whether it was apparent or not from the record, Lucy is a retiree on a limited, let's say, retiree's stipend. She's not out there earning chief executive salaries at Mobil Oil. Was a public school teacher. That was in the record. And for that reason, these taxes are a significant expense to her. Now, your question went further to the tally of monies that were paid by CEI. Those were in the record, and the evidence of certain tables and exhibits that were Guam water payments and Guam water payments, Guam power, Guam water payments, telephone cable payments, as well as the tax payments were presented to the court. And at one point, the court seized on some.
Sorry. But there are some numbers presented, and on the total distributions to each of the heirs, and one of them was a $1.2 million that went to Lucy, while the other heirs received some more. I guess the max was 1.5 given to another heir. Were these payments and taxes and repairs subtracted from the supposedly 1.5 million go to each of the heirs? And again, in the first place, Lucy should have gotten a $375,000 housing allowance, which she did not. I guess we have to subtract the $160,000 in house construction costs and maybe the remainder for repairs and insurance and taxes. That's not clear to me at this point, but maybe you can clarify that.
Thank you, Justice Magdalena. Of the several numbers you've presented in the question, one or two are absolutely clear to me. One is that the $161,000 was the evidence for Chamorro Equities' payment to build the house and construct it in 1990. The other number, I'm afraid to say, was just not familiar to me. I don't know of any of the heirs receiving $1.5 million in cash or any distribution of millions of dollars in cash from any source. They received periodic dividend distributions, but nothing on the order of $1 million or anything even above $50,000 or $100,000. The other number familiar to me was $375,000. And that is an interesting discussion because in the original plan made for housing benefits for the 7 siblings, a lot in Agana Heights was promised or agreed to. But that changed and it became an entirely new plan after that was abandoned because only 3 of 7 siblings took $375,000 to buy their homes offshore or in mainland USA out of Guam. And the other 4 had different arrangements. And those 4 are part of our brief because they're individually specific different agreements. For example, Priscilla received Mother Maria Joa's Talent Oregon home. She accepted that in lieu of anything else. And Alvin stayed in Debbie Doe in his house that he'd always been in, but he got a housing stipend or additional allowance to equalize him to the $375,000. Paul Ujoa, who goes by nickname Dan, he took the lot in Agana Heights and he had a house built there for his purposes. And Lucy had something entirely different, that her house was built by CEI money, and then she just took occupancy and possession without paying the rent. And that was her package. So
that was my question to you, counsel. I'm sorry if I didn't phrase it earlier, but why is it that Lucy's house is part of the corporation, but everybody else has their own personal houses, right? You
Yes,
see the difference, right?
yes. Thank you, Camacho. The explanation presented in the trial and the briefs is that each sibling had a different deal. Everybody had a separate package. The 3 that were identical were 3 of 7 siblings who got the $375,000 cash that they wanted to.
Isn't the Chamorro Equities really a mechanism for the family to kind of pool their resources? And then each of them obviously has slightly different place in their life, right? Some people already had houses, some people were looking for houses in the mainland. But this was a family corporation to kind of spread the wealth, so to speak, and according to each of their individual needs. Right? So why is it the house in Oregon not part of the corporation, but Lucy's house is part of the corporation?
Judge Camacho, I take your question to mean, what was there a family agreement consensus on these distributions? And there was. We freely are happy to advocate and agree with that there is the effort by the family to equalize and try to make roughly fair the distribution of housing benefits. That's why they created the table of 20 years covering 87 to 07, to find, are these roughly equal? But no, they're not exactly equal. They're all different in different ways. So Priscilla will live rent-free in the house she receives from her mother, Maria Joa, and Lucy will live rent-free in the house that she will occupy and possess from Chamorro Equities, Inc. And
So the other siblings of Lucy, were their houses part of the corporation? Are you taking that position? Or is just Lucy's house?
you could say just Lucy's house is owned by the corporation.
Okay.
Priscilla's came from the same source, the mother, and she just received it directly, but received no maintenance money. The repairs, home insurance, the taxes, that was on Priscilla's account. That's not CEI paying that.
But including the houses in Oregon or any other purchase of houses, right? They're not really part of the ledger, right? I mean, there's some payments because it's a family corporation, but you're not taking the position that those houses are owned by the corporation outside of Lucy's house.
It's important, Judge Camacho, that you highlight what should be an accurate or fine line table, Exhibit 9. But as the evidence was presented in the briefs will show you, the only witness for table Exhibit 9 was Richard McCurdy, who freely admitted it's totally inaccurate, it leaves things out, and it is really unreliable as an accounting measure. That was from the source, Richard McCurdy. So it's an effort, and Richard Ujoa, who created the table, sorry to say, passed away in 2017, not a witness available for the case at trial, which is part of our laches argument. So you have this roughly unexplained table trying to equalize the 7 siblings because it concerned probably some of them that they have a rough equal measure of distribution. And it's not—
Mr. Berman, let me ask you
Yes,
a
sir.
different issue because your time is winding down. On the issue of the statute of frauds, I'm a little confused in the interplay between the Estoppel exception and the statute of frauds. As we know, 21 GCA 4101 requires any conveyance of real property to be in writing. And the doctrine of Estoppel creates an exception with that where there is an oral gift and the donee grantee relies on that, and the test then makes these expenditures that enhances the value of the property, that the court will recognize an exception and allow an oral transfer of real property. So I'm a little confused in reference in applying the Estoppel doctrine here. As illustrated by these questions in reference to how much was spent, who it's going to be credited by, and how is it that Lucy satisfied the tests that is set out in the case. Green versus Brown is a California case that announced the tests for enhancing the value. So then the trial court found that in Lucy giving up her $375,000, that was part of the enhancement, that and the amounts, although as Justice Langlonia points out, that is a little confusing, and the trial court said I think there was an additional $5,000 that was credited to Lucy's account. So how is it that the Estoppel doctrine applies here to take this out of the statute of frauds in reference to meeting the green test, that there was detrimental reliance and therefore this shareholders agreement should be enforced because it would be unjust, extremely unfair not to carry this out? How did the trial court satisfy this test that there was this reliance on the part of Lucy that led her to make all these expenditures that exceeded the value of the property, and therefore it would be unjust to not enforce this oral agreement?
Thank you, Justice Carpenter. In our briefing, I believe we've tried to explain the error of the trial court in applying the Estoppel doctrines, both equitable and promissory estoppel, under the Supreme Court of Guam's watershed case of In re Moylan. And let's talk about the facts first. We believe the record shows us that there are no Lucy Ujoa improvements to the residence. That is, Lucy Ujoa is not paying to build an extension or build a new roof, add some bedrooms. This house was complete on construction in 1990, 7 bedrooms, 6 baths. There's no detrimental reliance by making further investment and add on fixtures like a swimming pool to this house. She just lives in it rent free for the 24 years. So that element, which we believe is pivotal and critical, is missing. And it shouldn't be applied for a factual reason. But the legal elements in both the Moylan test, equitable estoppel, promissory estoppel, focus on both a legal statement, and I'm going to start with that first, quote, equitable estoppel will not operate to remove a case from the statute of frauds when the promise relied upon is the very promise the statute declares unenforceable if not in writing. So the court must be very careful not to throw away the statute of frauds when it is the very promise that, in this case, Vivian is relying on, that Lucy had accepted to have a home provided in a lot. And the court went on to say, quote, were this not the rule, the statute would be rendered virtually meaningless because the frustrated claimant would always assert an oral promise to defeat by means of estoppel the statute's requirement, close quote. Alternatively, the promissory estoppel doctrine is not going to apply here under Moylan because that applies, quote, only where circumstances are so egregious as to render it inequitable for a court of justice to apply the statute of frauds. Here, we don't have egregious facts. We have a balanced out arrangement. Lucy's accepting rent-free living in a house supported by CEI money for taxes, repairs, maintenance, insurance, and then power, water, utilities. And that package makes this better than fair and certainly not egregious. So for those reasons, estoppel under our briefing and the facts of the trial record shouldn't apply in this case at all. Thank you, Justice.
Well, your time of is up, and you reserve 5 minutes.
Thank you.
So we'll let you reserve the balance of your time. At this time, I will recognize Attorney Jackie Turley. Please proceed, Attorney Turley.
May it please the court, half a day, justices. Equitable estoppel was properly weighed and applied by the trial court, and its finding enforcing the oral agreement to transfer real property between the 7 sibling shareholders of CEI and Lucy Ujoa must be enforced to prevent manifest injustice against an elderly, incompetent woman's estate. Because equitable estoppel appears to be at the center of many of the legal issues addressed in this case, I'd like to first address the equitable estoppel issues. The trial court in this case ruled directly on equitable estoppel and properly applied the In re Moylan standard in 2011 Guam 16. The first factor that the trial court looked at was the existence of extreme circumstances to prevent an injustice to the donee. The donee in this case was Lucy Ujoa. Everyone knew that she was under a guardianship proceeding. She is the eldest sister of the 7 siblings and has been incompetent by guardianship order as early as 2005. She was deceased in 2014, and the trial court held that she would have been significantly deprived of the value of a housing allowance that was received by the remaining sibling shareholders. So the court, in determining the existence of extreme circumstances, weighed all the issues that CEI has asked today that this court review. The second issue.
But before you move on, as Mr. Berman points out, there must be some type of expenditure on the part of the donee that relied on the oral promise, and it would be manifestly unjust, unfair, as you pointed out in the In re Moylan case. And I understand the argument that under the shareholders agreement, Lucy was to receive $375,000, and she didn't receive that. outright cash, but the argument that is made is that she stayed in this home for 25 years or so rent-free. And so if anything, there may be an offset, but an offset where Lucy is allowed to stay in the home, not paying any rent, what there is no detrimental reliance. There's no expenditure on the part of Lucy above and beyond what she felt that she was entitled to. So that's where I'm a little confused, because there doesn't seem to be that to be factored in trying to determine what was Lucy out of pocket that would make it unfair now for the court not to transfer the house to Lucy when she had also received this benefit during her lifetime that apparently was not accounted for.
Thank you, Chief Justice. That's an important question because you're asking about the financial impact on the donee and that of the donor in comparison. In this particular case, it's very different from the Moylan situation where there was an oral gift that was given. In this instance, it does not involve a gift. And so the court needs to take a step back and look at the factors that it has imposed in the enforceability of an oral agreement. And when the court looks at what an oral agreement is, the court has said that the reliance or change in position to one's detriment. In the context of an oral gift, the Moylan case said that there has to be some kind of detrimental reliance in improvement to the property, for example, is what the court gave us. In this particular instance, the detriment to Lucy Ujoa was not enforcing her $375,000 housing allowance. She lost the value of the $375,000 over the 24 years that she was sitting in the residence, a value that all of her other sibling shareholders shared, as is evident by the finding of the trial court that she received significantly less distribution than that of her other siblings. So when the court looks at what detrimental reliance was taken by the donee, in this case, Lucy Ujoa, the court must consider the loss of the $375,000 over that 24-year period.
But isn't it that Lucy received the $375,000, the arguments made in the form of free rent? Otherwise, she's not entitled to that. If she was to rent a premises different from what she was living and was paying rent and then expecting this $375,000, she didn't receive it and she continued to pay rent to live somewhere else, and then relied that she would receive the property, then an argument then can be made that she didn't receive the benefit of the $375,000, made expenditures in reliance of the property, and I don't know how that would interplay here. It's probably a poor hypothetical, but I'm just trying to resolve in my mind what was the detriment. It can't be just a wash. At least that's not my understanding of the test that we announced in Moylan in terms of the Estoppel doctrine. We're saying here that CEI is stopped from insisting that there be a written agreement because there was this shareholders agreement that promised to convey this property to Lucy. Well, it just doesn't end there. That is not the doctrine. The doctrine is, and Lucy then took steps to enhance the value of the property, and therefore it would be grossly unfair for this court not to enforce the oral promise. But I don't see, the argument that I think the trial court made or the trial court decided was that, well, she gave up the $375,000 and that's the detrimental reliance. But then you need to go a step further, but she didn't really give up that $375,000 because she received it in the form of free rent. So it should be, it may be a wash. There was no valuation, but living in that large a home over a period of 20 years will add up in reference to, and so I'm just saying that where is the gross inequity to Lucy when she did get the some benefit in continuing to stay on the home, Ganya Heights home.
Yes. Thank you, Chief Justice. Yes, and you're right. The analysis does require us to look at the financial impact as compared in this particular case to the 6 other sibling shareholders. Justice Camacho pointed out the Oregon property. The Oregon property is the most similar to the particular situation in that the house was previously owned by their mother and was in fact transferred to June Hartwick. June Hartwick received the benefit of that house. She did not pay for rent. The only party who is being imposed upon or compelled to prove a negative is Lucy Ujoa. Lucy Ujoa has expended funds. If the court reviews the record, one of the significant funds expended by Lucy Ujoa was a $55,000 survey fee that was required to be paid to anticipate the partition of this particular property. That is definitely a significant expenditure in terms of the overall expense that's involved. The payment of real property taxes, as Justice Camacho points out, as well, it may be an insignificant factor, but if the court reviews the records, all the amounts attributable to Lucy Ujoa's Agana Heights house were attached to Lucy Ujoa's distribution and income. So although the money may have come directly from Chamorro Equities checking account and paid directly to the source, Lucy Ujoa was tagged with the distribution of those particular amounts. So any amount that came out of CEI to pay for the expenditure of these things and are identified on the distribution logs that are before the court are properly Lucy Ujoa's expenditures because she is the one who paid the taxes on the distribution of income. So although minute, in terms of the overall expense, it did not hit $375,000, but those amounts were in fact her income, her expenditure, although from, as I said, from the CEI coffers is where it came from, the direct source. So while we may not see Lucy Ujoa writing an individual check and saying, I paid $500 for power, we have the converse in this situation where CEI pays the $500 in power, but then puts it on her distribution and the reporting of income for her for those particular years. And when the court looks at the amounts that are attributable to her, she's only attributed $1.2 million as compared to the $1.5 million that another shareholder receives. So when we talk about gross inequity and the disproportionality that is being imposed upon an elderly and incompetent woman, that by itself is a manifest injustice in this particular case. And so this is the reason.
I don't know, Attorney Terlai, if really that's the analysis. I don't think the analysis is you compare Lucy's circumstance to the other siblings. At least that's not the way I understand. I mean, in order for Estoppel to apply, I don't know necessarily that there's a comparison of one family member against another. It's, there was a home, say, we give the benefit to Lucy of $161,000, the cost to build a house. And she spent over $300,000 to enhance the value of the home. And therefore, it would be now grossly unfair for her not to receive that home in Agana Heights after having expended that amount of money. That, I thought, is the Moylan analysis and test. And here, if you give all the credit that, the trial court enumerated, I don't see where the number was produced that it exceeded 161,000. Of course, Mr. Berman is going to say, well, the argument is it should be 500-some thousand because that's the appraisal of the property. But even, giving the benefit to Lucy in the analysis, And I don't necessarily see it that we compare it one family members to what they receive as opposed to another. It's more focus in reference to the test.
And that's where, Chief Justice, I think it's important for the court to consider the context in which the court is faced with the particular donee. So in this particular instance, the donee is placed at a significant disadvantage because there is no dispute that the donor has agreed, has conceded, and has admitted that they agreed to transfer the property. And so at a belated time frame now, what we have here is a circumstance where the donor has now retracted and saying, no, there was a change of agreement. Well, where was the evidence of the change of agreement? At the trial court level, the court did not find that there was a change of agreement. In fact, there was no evidence presented of a change of agreement. There has to be a meeting of the minds as held by the trial court in order for there to have been a change of agreement to substantiate on either accord or satisfaction, or in this particular case, the equitable estoppel factors. This is why I say the most important factor that you have here is the fact that CEI does not dispute that they made the agreement to transfer the real property. And when you put that in the—
I don't think anyone is disputing that. I don't even think Mr. Berman is disputing that there was a shareholders agreement. And
not at this phase, Your Honor. You're correct, Your Honor. Not at this phase. CEI does not dispute particular phase. But if the court looks at the record, there has been a long dispute about the disagreement and whether they in fact agreed to transfer that property. So if the court looks back at the motions—
Ursula, if I could just interject here. What really, I can't get past the first factor of injustice to Lucy here. The extreme circumstances, and Attorney Berman mentioned that there's nothing egregious here. Lucy seems to be a key player here. She was a director, and it was pointed out in the briefs that she signed minutes where certain references were made that CEI owns Lucy. So, and she was a signatory of that petition for land registration. So she could have done these things during the 20 years, maybe up until 2005. So I'm thinking, how do I reconcile this? How do we reconcile it with more than one, and maybe even the 2017 more than opinion? So can you shed light on that?
Yes, thank you, Justice, for the question, because I think it's important to think about the Land Registration Act in context of your question. In this particular instance, we have an agreement amongst siblings to partition and to transfer property. You cannot do that without registering the property first. So is this court inclined to hold that in order to preserve your agreement to partition property, that there has to be a written agreement to that effect before land registration, would go against the decades of the way that land registration cases have been handled on this island? So before you can actually partition property, that belongs in common between sibling landowners or any related landowners. Then you have to register. You register the property, and then there's a partition. That's what you see that was done in this particular case. The siblings went forward into a probate proceeding, were able to get the property decreed by a probate decree to their names in equal shares. And then the siblings took that decree and then they sought the registration of that property. Prior to the registration of that property, the siblings had agreed this was what was going to happen. We're going to partition this property. We're going to go ahead and build Lucy's house on this lot. And after we partition the property, then that's when we're going to go ahead and transfer Lucy's house. As you can see from the trial record, in this particular instance, there were many difficulties with the partitioning of the property due to easements, the location of the house, the sewer, the septic tank. These types of things were considered by the trial court. And this is why the trial court's determination of the credibility of the evidence before it and the reasons why Lucy may or may not have taken certain positions, including in the minutes as the eldest sibling, as the eldest elderly sibling, then that's the very reason why the trial court is in the best position to weigh all of the evidence. This was the kind of evidence.
Did the partition happen in 1993? I see some date here in the map that was included in the excerpts. Did that happen in 1993 before the land registration petition?
No, there was an attempt to partition the property, but the partitioning only occurred after the death of Dan Ujoa. Dan Ujoa ended up suing CEI for his share of the particular piece of property. And there was an agreement entered into between CEI and Dan Ujoa's estate. So it was subsequent to his death, but I do not recall in terms of the record of the timing of his death. But the timing of his death was after we had already instituted several matters of litigation. So my point to the partitioning and the registration process is simply that the trial court had before it all of this particularized evidence. And going back to your question about, well, why did Lucy Ujoa take certain conduct? Why didn't she assert the right to demand the transfer of the house during the time frame that the property was not partitioned? Why was that not in the minutes? The same could be said. Why was it not in the minutes that Lucy accepted rental in exchange of the agreement that CEI does not dispute that they should have transferred this house to her? So what you have here is you have an elderly, incompetent woman who basically did not take a position at a certain point and was and is being deprived of the asset to her estate, irrespective of the value to Lucy during her lifetime. The value to her estate is quite significant in the amount of $500,000.
Let me just pause here, Attorney Terlai, because what I understand is you're asking us to, because of this oral arrangement, for us to just ignore the Land Registration Act and the requirements in the act. And that's very difficult for me to do. I mean, if you have a warranty deed that represents to the world that this property is owned by X company, you then proceed to file a petition for land registration where the purported grantee represents in the petition that there are no claims whatsoever, no agreements whatsoever that creates a cloud on this title, and this decree that the court is going to issue is free and clear of any encumbrances, at least the representation of an oral promise to convey, and then come back the very next day after the decree is issued and say, oops, it's subject to this agreement and it would be unjust. You're asking me to ignore the effect of a decree of land registration, to ignore a recorded warranty deed, and where the perpetrator is the very person who filed the petition and is the one now saying that it in fact is not true. What I stated in that petition, it was not accurate, and therefore I want to undo that. That's very difficult, because you know what would have happened if CEI had sold that property to a bona fide purchaser after? Would then that oral promise to convey affect the conveyance to the BFP? That would be a real question that we would then have to struggle with, that the Land Registration Act doesn't mean what it says.
And Chief Justice, I thank you for the question, because you're absolutely right about the Guam Land Registration Act. It was intended to protect and to afford protection to bona fide purchasers. We don't have bona fide purchasers here. We have the original landowners here involved in this particular case. And as this court has recognized on several instances, fraud is an exception to the Guam Land Registration Act, with the exception of the protections afforded to bona fide purchasers of that particular land. And so if, assuming the facts as you have presented, the hypothetical you've presented, where we have a bona fide purchaser impacted by the Guam Land Registration Act, right? I would take the position that due diligence would have required those bona fide purchasers to review the records as CEI has it. When you review the CEI records, it is clear that CEI says that the house belonged to Lucy. Lucy's house.
But let me just say, that attorney's like, the BFP would rely on a title report, would rely on the grantor-grantee index, not some private corporations, private books that may not even be disclosed to the BFP. But even setting that aside, that hypothetical, what about the statute of limitation in the Land Registration Act that forecloses, bars any type of claim that preceded the initial registration if is not filed within 1 year, 1 year of the decree of land registration? And in this particular case, the very person who is now had notice and knowledge of that petition for land registration. So Lucy can't very well argue that I had no knowledge of the petition for land registration. Therefore, that petition is not binding on me. Even that we don't have in this case.
And Chief Justice, we are not challenging any fraud as to the registration of the property. And I think that that is a distinction that needs to be made in this particular instance. The fraud alleged in this case, or the misrepresentation, the mistake that is alleged in this case, is that CEI entered into an oral agreement with Lucy Ulloa and did not perform that agreement, whereas it did in fact complete its performance of its agreement with the other shareholders of
So
CEI.
isn't the remedy then to Lucy to sue to recover the $375,000? There are too many obstacles to undo a land conveyance, a petition for land registration, in order to enforce an oral promise. And if there is an apparent inequity, because against Mr. Berman will argue, well, she got the benefit of the rent-free and all that. But isn't the remedy then to sue for the $375,000 if she feels that she has been treated unequally when compared to her other siblings, rather than to go against the verification, the petition, the representation to the world that this warranty deed and this decree of land registration really doesn't mean what it says?
And Your Honor, and this is why I say that this case is not the same kind of case that you would have on an allegation of fraud of the registration. What we have is a case that looks like a fraud case or is pled in the context of a fraud case on an oral promise that was not completed. And in this instance, we're not talking about a bona fide purchaser. The Guam Land Registration Act was created to protect the bona fide purchaser. We don't have bona fide purchasers here. We have the original registrant to the property. And so should we excuse that one instance where Lucy Ulloa signed off on the petition for registration? If the court does not want to excuse that, should then the court also excuse the affirmation and reaffirmation of the oral promises made to Lucy Ulloa of their intention to transfer this real property to her, including the intention and the continual intention to subdivide and partition this property? So notwithstanding the fact that Lucy Ulloa engaged in certain conduct in 1995, throughout the years of, I believe after 2000, CEI continually attempted to review the property in the context of partition to fulfill its obligation. And that's the very reason why I hearken back to the trial court's findings of fact in this particular case. The appellant has not established an abuse of discretion. An abuse of discretion requires that the court to have erroneously relied on a fact that is not supported by the record or an erroneous determination of law.
Let me just say that I could have some understanding, empathy, if this oral agreement to convey occurred after 1997, after the petition for land registration. If then there was this agreement that the shareholders all agreed that this property would be Lucy's and that they should, and that there is an oral promise to convey, then that was not carried out, then I think there is a different equity argument that oral promise, provided that you come under the Estoppel because you got the statute of frauds. But here we had the oral promise that was made prior to the petition for land registration, prior to that warranty deed being made. And so to me, there is some legal significance if we are to recognize the effect of the Land Registration Act in that oral promise potentially not surviving the decree of land registration.
And in addition to that, excuse me, it was mentioned, the warranty deeds were mentioned, and we're not just dealing with one warranty deed here. We're talking about 1987 deed, the 2005, I believe it was a January warranty deed, and then there was a corrected warranty deed later that year. So those deeds serve notice to the entire world, as Chief Justice Carbolito mentioned, that there's a I guess, a tracking of ownership of this property. And also in the petition, as was mentioned earlier, Lucy signed the petition for the title registration. So again, that's troubling to me when we have this land registration provisions that require landowners to give notice.
And justices, and this is the very reason why there is a fraud exception. Because every act that CEI took to promise Lucy Ulloa the transfer of that real property, that's what takes it outside of the Land Registration Act. It takes it straight into fraud. And on that basis, equitable estoppel should be applied to avoid the injustice to Lucy's estate.
CJ, can I ask?
I'm sorry. Yes, absolutely. Yes.
I apologize. Counsel Terlai, as to there was a will from Lucy, right?
That's correct, Your Honor.
Now, in the will, did she say, all my worldly goods to Chamorro Equities or to my siblings?
She left her residue of her estate to her siblings and specific property as well to her siblings, not to CEI.
Including the house? Did she say, including my house, or just kind of a catch-all phrase, like whatever the remainder is, I give to my siblings?
Your Honor, no, there was no provision for the house made in her will. And that is an argument that was presented to the trial court from both sides. CEI asserted that the lack of the citation of the house in the will means one thing, and we presented that the lack of citation of the house in the will meant another. In the end, the trial court did not address specifically that issue, that this is what the lack of the identification in the will meant. That was not a finding of fact of the trial court.
So are you able to reconcile the Land Registration Act and the will by arguing that somewhere embedded in the will, or can I catch a phrase that also that TCU owns the property? Are you able to reconcile that or not?
Yes, Your Honor. If I may, the reconciliation I would offer to the court is that when you look at the circumstances of this case, you have an 80-year-old woman who is not sophisticated. You have a family who's not sophisticated that's entering into a sophisticated process of corporations and making promises amongst themselves and trying to be as fair and as equitable as possible. And in the end, if that was the promises that was made between the siblings to be fair and equitable, when you look at all the facts in this case, the trial court found that Lucy Ujoa was not treated fairly or equitably, and that CEI failed to transfer the house when it promised to. Thank you.
Thank you, CJ. Thank you, Counsel.
Thank you, Attorney Terlahi. Mr. Berman, you used all your time, but I'll give you 2 minutes to wrap up. I'm sorry, you are muted, Mr. Berman. I said, according to the courtroom clerk, you've used your entire 30 minutes, but I will give you 2 minutes to wrap up.
Thank you, Your Honor, and I will be brief. In particular, just addressing the exchanges with opposing counsel. Number one, the petition for registration of that title was signed in 1995 in the consultation with private counsel, who at that time is on the paperwork, Attorney Jesus Utoris. That would be the time for Lucy Ujoa to be consulting with any counsel on her rights. Secondly, I don't understand the opposition argument that Lucy somehow committed fraud on herself. So Lucy's petition to register title is fraud on herself. It doesn't really pass the legal muster of review here. The other item about fraud, the court will notice in the decision order denying summary judgment to Chamorro Equities on its statute of limitations argument, had another section which actually granted summary judgment to Chamorro Equities to dismiss the fraud claim of Vivian McCurdy. So that was part of the summary judgment process. One of the facts maybe being overlooked here in the package which Lucy Ujoa had was that she's having her home, her residence being taken care of by others, CEI in particular. At a time when she's physically and mentally declining, that is an intangible, very high value benefit. Now, that's an assisted living benefit, and her home would be taken care of by others. You can't dismiss that so lightly as saying, oh, it's just rent-free living. It's more than that. Now, just turning to the statute of limitations briefly, I think our briefs explain why we think there's 9 triggers, and those dates begin in the 90s, particularly 1990, but they also extend to 2005, 2007, 2011, and 2012. And we'll let our record speak for itself in our briefs. Thank you, Your Honor. We ask you to reverse.
Thank you, Mr. Berman. Thank you, Attorney Terlahi. The court will take the matter under advisement, and the court now stands adjourned.
Thank you, Your Honors.